class is all about battles for equality. We're going to look at the 14th Amendment in a deep dive. We're going to start during the Reconstruction time period and move all the way to modern times. So there's a lot to go through. I'll be here today to help you out. My name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center. And to do this today, we are lucky to have Nick Mosvick with us. And he's going to walk us through this big topic. Nick, would you like to say hi to everybody?
Hi, I'm Nick, and I am one of our senior fellows in constitutional content. And as we learn every week, we should just get going.
Yeah.
Enough about me, let's start talking.
Yeah, you don't need about us. We're here to help you. You use the chat, you use the Q&A, and we will try to answer all the questions that you have. Now, Nick, the 14th Amendment is huge. I like to say it's a great topic to talk before Thanksgiving because it gives us a lot to be thankful for. But can you help our students kind of get a frame of reference of when was the 14th Amendment written? What was going on in that time period? What was the years? And then what was the goals of the original writers? What were they trying to do? And then what we're going to do is break down that 14th Amendment, kind of say what are each major parts of the 14th Amendment, and then walk us through the history from the Reconstruction time period to today and look at the modern implications and how much do we use the 14th Amendment today? I always feel like it's the one that we're constantly talking about, even when we're talking about other amendments combined. But that's a big, tall order for today. So are you ready to dive in?
Yeah. So
great.
Let's get started. That's kind of the basic overview. And I think what we start with here is kind of where we left off last time. So last week, we talked about, our topic was slavery in the Constitution, but we're also really kind of talking about the lead up to the Civil War amendments and the 14th Amendment in particular. So we ended at the Civil War and Reconstruction. And it's worth reminding ourselves of that basic history when we get started today. And the reason is that explains exactly what the founders and framers of these amendments, particularly the 14th Amendment, were trying to do. What were they trying to solve? What issue had they identified? And in particular, that issue is that they felt like the original Constitution, even if it was supposed to protect this basic equality, had not done so. And so it needed to be restated, re-emphasized in the Constitution through an amendment so that it would protect all citizens, right? And let's remind ourselves of why, in particular, that was necessary. And that's both the Civil War itself and the Dred Scott case, right? So we talked about Dred Scott for a while last week. We don't have to go over the particulars again, but just remember that the result of that is that all African Americans are denied citizenship under the Constitution. And that's a very important reversal, right? So it's not just about granting citizenship, right? It's also about the basic equal rights that are attendant to that citizenship that are granted, right? And that the Civil War itself is symbolic of this fight, right? That the outcome of that war is very important, right? This amendment is linked to that. That's just kind of a basic historical frame, is that at least 750,000 Americans died in that war. And of course, its aim shifted over time, right? It was about maintaining the Union, but also destroying slavery, right? And to destroy slavery and to reunite the country, those who had, the Republicans who were in control of Congress, did not want to give up this battle over equal equality, right? They thought without it, it would have been almost as if we lost the war, right? So that's the connection, is that we won this war. What did we win?
Got it.
How can we secure that victory in a constitutional sense? So just think of it that way.
So I think that's a great way to think about it. We have this awful war that is fighting to secure the Union, to end slavery, and to bring in equality into our country. But without putting it in the Constitution, you won't really have it, or you don't have a guarantee. And even with it, we don't always have a guarantee. Over time, we see it differently. So I know the 14th Amendment is really long. I'm going to flash through each section really quickly. I don't expect you all to read this. I put the interactive Constitution in the chat so you guys can look closely as Nick kind of walks you through these pieces. But I know there's some big sections to the 14th Amendment. So Nick, do you want to break us down to these 4 big sections, and then we can start with birthright citizenship and go into each one?
Well, let's see. Let's do that and go ahead and back up so we can see the full text. We don't have to read through literally all of it, but it's important to go piece by piece. Those 4 big features, we're mostly talking about Section 1. So when we say we're talking about the 14th Amendment, we're almost always talking about Section 1. That's where the 4 sort of basic rights, freedoms, protections are put. So Kerry first is highlighting birthright citizenship. Jeff mentioned this last week. We mentioned this. Civil Rights Act of 1860 is very important for a variety of reasons. One of the reasons is it's the first time we see birthright citizenship written into a congressional act. But of course, Congress is worried that an act is not sufficient to maintain it permanently, therefore an amendment is needed. And once again, this reverses Dred Scott, right? Remember that birthright citizenship is the opposite of Dred Scott, right? There's no racial basis for citizenship in this country. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. That's it. And so it is broad-based granting of citizenship. What are the other 3? We have no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. As we talk about, the framers there a lot of scholars believe that the framers of the amendment hoped that that section would, if it didn't apply the Bill of Rights of the states, would give this sort of protection of equal basic rights that the Civil Rights Act of 1866 was meant to start. Then there's the protection for due process of law. That's in the 5th Amendment as well, but now that's applied everywhere, right? And then no denial of the equal protection of the law, right? The equal protection clause, which as we get to the modern period, we'll see this shift over time from originally using the privileges or immunities as the means of protecting rights or trying to assert rights under it, towards both the due process clause and the equal protection clause, right? Equal protection is going to give us a lot of the protections against sex-based discrimination and other types of discrimination. Due process is going to afford rights like privacy. So we'll get to that when we talk about more modern pieces. When we go through the rest of the sections there just really quickly, I mean, the middle sections of the 14th Amendment, they're about the war. So Section 2 is important because, for one, mail is used in the Constitution for the first time in Section 2. That very much upsets many of the suffragists, which you can see in our great history and panel of the 19th Amendment, our exhibit. But it mentions that, right? It also excludes Indians not taxed. We'll talk about that a little bit, just to note that citizenship was not intended to imply to Indians of a native nation, right? So they were considered outside, right? So that language was important, because a lot of the debate over the 14th Amendment was, are we going to apply this to Chinese immigrants and to Native Americans? So that was one of the big concerns about extending citizenship too broadly. And as we'll see, the fights over citizenship really did not stop, right? That fuel kept going. But we'll see that also, if the African-American vote was denied, there would be punishment for these former Confederate states that had come back in. They would have lost representation in Congress, was the idea. They could be punished for not giving that right to vote. So you can see here that Congress already is aware that the southern states are trying to take away the black vote, right? Section 3, Section 4, these are about the war itself. This is about Confederate debt, former Confederates taking office. It mattered a lot at the time, but of course, no one sues over that because the Civil War is no longer a problem, a modern problem, right? It was solved by that. Section 5 is really important. We've talked about this with the 13th Amendment. We'll talk about with the 15th. They all have something called an enforcement clause in them, meaning that Congress has the power to enforce by appropriate legislation the rights in Section 1, right? So as we talk about, this is a shift in terms of who in what government is offering these basic fundamental protections for liberties and rights and equality, right? there's a shift in this amendment from predominantly state governments doing this to the federal government taking a more active role, right? The extent to which that shift happens, that's a part of the Supreme Court's debate early on, but definitely the enforcement clause is really important.
Yeah, and I think this is when we talk about like the power between the federal government and the states, federalism, when we talk about the second founding, these are because these enforcement clauses are a lot of power in there. There's a lot of powers in Congress. You now have, the power and the responsibility to do this. So when you hear these discussions and debates of why this time period was so important, when we're thinking of the power that it's given to the federal government and the eyes are turned on the federal government to protect the individual, that's a completely reshifting from the revolutionary period when people were worried about that federal government. It was like, no, back off. The states are going to be protecting you from us. Now it's a flip flop. Okay, so you
talked about duty. That's also important too, right? It's not just about power, but about obligation and duty. And that indeed, early on, states were believed to be the fount of that for citizens. And so the experience of the Civil War does shift that attitude. But as we'll see, the Supreme Court, politics, there's a fight over the extent to which federalism has been changed. That's a big part of these amendments.
So what I thought would be really great, because I know we have got 18 minutes to go and we have a lot to go through. We talked a little bit about birthright citizenship. We talked about protection of equality, protection of freedom. Congress is now given more power, some kind of big key elements, key features of the 14th Amendment. But do you want to start with John Bingham? You want to dive into some of the writers and then go to Plessy? How would you like to kind of walk through this next piece, Nick?
I mean, we can start with John Bingham, and then we can try to get to Plessy. We kind of have to skip across the pond, so to speak. So we have to touch on Slaughterhouse at least, so we can explain what happened. But John Bingham is the principal framer of the 14th Amendment, which we introduced last week. Bingham believed that the Bill of Rights already applied to the states. That we had kind of gotten that wrong. The Supreme Court had gotten that wrong. And the 14th Amendment was righting that wrong, and that it was giving this principle of quality guaranteed throughout the land to all citizens, right? As kind of this, again, this broad protection of basic rights and equality for all citizens, right? That was the big goal. And then applying the Bill of Rights to the states, that was part of that goal, right? How are we going to do this? What was the problem, right? Just again, think about it that way, right? They had to identify what was the issue. What did we gain in the war? What are we going to do? And this is the solution, right? This is what Bingham wants to do. Slaughterhouse cases happened in 1873. The reason we have to talk about it, you can't avoid the Slaughterhouse cases because it's the first major interpretation of the 14th Amendment by the Supreme Court.
As much as I'd like to try to avoid them.
Kerry would like to try.
First of all, guys,
it's impossible.
It's a real slaughterhouse. So like, it's not like somebody's name slaughter and then like against house, but it's a real slaughterhouse. And the reason, and just so we're fair, the reason why I like to avoid it is it's a little confusing.
It's a very cluttered case.
Yes.
I know because I've written mounds of pages on it. So the amount of argument, just types of arguments in this case, it took basically a week of oral argument. Think about it that way. There were so many arguments presented in this case, in part because it was the first exploration of the 14th Amendment. While the Slaughterhouse cases, that was a group of butchers, and they essentially used every possible argument they could. And the problem was there was a monopoly granted by the New Orleans government. At this point, the legislator was a biracial legislator under the Reconstruction Acts. They had elected a combination of African American and white legislators, and they had passed some pretty serious radical reforms. And one of them was to grant this monopoly because of public health problems. Well, so that was challenged, and it was challenged under the Privileges or Immunities Clause, due process, equal protection, all these things. The case, many ways people understand it, is taking apart the Privileges or Immunities Clause. Because what the Supreme Court said is, look, all that Privileges or Immunities Clause does is to guarantee rights for all citizens that were already guaranteed by the Constitution, by which they meant the right to petition, the right, to protection on the high seas. They did not mean these rights like the right to work, the right to contract, or a right against monopolies, right? And part of this interpretation was to say the 14th Amendment didn't take away the police power of the states. They always had those powers to regulate public health and morals and the people generally, right? The states always had those strong powers. We don't think that was changed. And the Supreme Court essentially said that they read the 14th Amendment as being primarily about discrimination against African Americans. And so that this principle didn't have a lot of an effect outside of that context. There were 3 dissents in the slaughterhouse cases. The real big takeaway there is, yes, they argued about privileges and immunities. We don't have to get deep into that. But Justice Swain said, look, I mean, read the debates, read what the framers said, and it's hard not to see that they meant for big changes. Mm-hmm. And we don't get to decide whether or not that big change happened. Congress and the American people get to decide, and they did so. There was an amendment process. So you can see that slaughterhouse also shows you the heart of the debate is really how much has changed. And slaughterhouse suggests not very much. We're not comfortable moving that fast.
So if I if I think about the slaughterhouse case, and Nick, get me see if I'm right on this, like understanding, it takes this section, the privileges and immunities, and kind of makes it less powerful and like weakens it.
Arguably cuts it out according to many scholars, right?
Yeah. So I wanted to almost like lighten that, because when we look at like the power and the might in this amendment, we look at naturalization, we look at privileges, immunities, due process, and equal protection, some big kind of key law areas. So that case weakens or arguably takes out this section right here. So I wanted to kind of visually show everybody. But then how do we get kind of how do people in America kind of fight and say, no, that 14th Amendment was meant for change? How do they start to push back? And what are some of the cases or the moments where maybe people didn't win, but they saw kind of some gains?
Well, an important thing to observe is, people still tried to make arguments under privileges or immunities. Women in particular, there are 2 cases right out of slaughterhouse. One of them is the day after, which is about women practicing law in Illinois. And Myra Bradwell filed that under the privileges or immunities. And she said, this is an arbitrary distinction between the sexes. I should be able to practice and take the bar. Everyone knows I'm smart enough and I can do it. They denied that though. And it's, the opinion itself reads now rather sexist. If you want to go look it up, students can do so. The other one is Minor versus Happersett, which comes 2 years later in 1875. And Virginia, Minor, she was a suffragist leader. And she did what many other suffragists did, which is illegally voted. Soon after the 14th and 15th Amendment, they said, look, we're going to vote and we're going to try to challenge under the 14th or 15th Amendment and claim our right, because we think there's an argument here. They made natural rights arguments, they made 15th Amendment arguments even, but they also used privileges and immunity and said, look, I mean, citizenship is granted to all of us under Section 1 of the 14th Amendment. So we're citizens. Part of being a citizenship is the right to suffrage, and states can't have this kind of arbitrary distinction. That's privileges or immunities. Now, she lost that argument, but that was one that was made. So people did try to fight back. The shift in suffragists, of course, is the move towards pushing for an amendment. But in the 14th Amendment, the shift is, okay, so what do we have left? We have due process and we have equal protection. How can we use those to secure our rights if privileges or immunities isn't?
Got it. Now, great question from the chat. Amit says, when the government was writing the 14th Amendment, was the government viewed as radical, or were they considered normal, like basic? When we talk about radical, you mean like, one intense side. I wouldn't say partisan, but radical is a great way to say it. Or were they,
sometimes.
Or were they just viewed radical by the South?
Yeah, the radical Republican term is not necessarily just the South, but certainly opponents like Democrats, or there are moderate and conservative Republicans as well. So it's a term used in those historic debates. But what we're really saying is, look, the Republicans weren't monolithic. There were different factions of Republicans. The radicals were the ones who we designate them because they were pushing harder for all equality, right? They're thinking about things like universal right to vote. That would apply to women, African Americans, just broadly, right? They were thinking about equality, right, before anyone else was, and saying in 1865, 1866, even 1864, Thaddeus Stevens and others were talking about we need to have equality. We can't just end slavery. We need to guarantee equality because we have to integrate African Americans into American society. What pushes the moderates and some of the conservatives? It's the Black codes, the recalcitrant South, their fundamental inability to change. And it's Andrew Johnson, the president who takes over for Lincoln when he's assassinated. Andrew Johnson has his own Reconstruction program, and it's very simple. He says, okay, the former Confederate leaders probably can't be back in government. They got to take oaths. We have to have oaths. And all the states have to pass the 13th Amendment. They have to admit that slavery is over. Beyond that, Andrew Johnson isn't asking very much of these Confederate states. He's just letting them back in, and therefore they can pass those Black codes. He's not bothered by that. But the moderate Republicans and conservative Republicans are. That makes them say, okay, we have to do more. We need an amendment. We need acts. We have to guarantee a real Reconstruction because, as I noted at the beginning, right, the Civil War had to mean something. And so they looked at that situation and said, we have to act. So yeah, the radicals, we designate them because they were pushing harder for some of these other solutions and some things that became part of these amendments. But it was a whole effort, right? Because it required a lot of people to agree. And they agreed because they understood the threat to American society at the time.
Got it. So we've got the radical Republicans, we've got the 14th Amendment saying that we need things to be equal. We need the law to be equal, equal protection, due process, that you're a citizen, that you have a right, you are a person, a citizen here. And then we see our country start to say, oh, we'll make it equal by splitting things, which is inherently unequal. But can you walk us through kind of those big court cases, especially around segregation and education?
Yeah, so I think you put it well already, which is to say, look, what happens here, there's a couple shifts, right? Reconstruction ends, we traditionally say in 1877 after the election. It's part of the agreement. That's a contested election. Part of the agreement is to pull the federal troops out of the South. Remember, the federal army is in the South this whole time in many of these states. And they're there to ensure African Americans can vote, that they can stay in office without their lives being threatened, because they are being threatened. So that does change things. The other thing they learn, some of the Southern governments, and then Northern ones as well, is that, okay, we can't blatantly discriminate, but if you can pass a law that doesn't discriminate in its text, on its face, but then in action discriminate, it'll have the same effect, right? So this is the advent of what come to be known as the Jim Crow laws. And so that starts mostly in the 1880s, but really starts in the 1890s. So you see the Southern states pass these laws. You see new constitutions. So Southern states, South Carolina, Mississippi, most notably, get rid of the constitutions that they believed they were forced to write under Reconstruction, which had, of course, guaranteed broad rights and equality. They want to get rid of those, and then they pass these laws, right? So what is the law? What is the problem in Plessy versus Reagan? Well, it's the law of separate train cars, right? Now, the equality, their idea is, well, look, I mean, different races want to be apart from different races on cars. There's no discrimination here. We're just doing a natural thing, and people still get to ride the train. And so they're trying to claim there's no discrimination. Homer Plessy is, he's chosen. It's a test case. This is what we call this in constitutional law. What that means is he purposely was arrested. He was part of a citizens committee that wanted to challenge these Jim Crow laws. And he volunteered because he was 1/8 African American. He knew he appeared to be white, but was in fact Black, and wanted to show the arbitrariness of the law. In other words, that really, there was no equality here, right? This was just merely, how is it that the person in control on the train figures it out? They just figure out they know you're black, and then they, throw you to the other train. What is going on here? And saying that, look, under the 14th Amendment, you can't have that, right? That's not equal protection. So that was the challenge. And the Supreme Court upheld Louisiana's law here 8-1. And the opinion is written by a man born in New England.
And I think that's really important as you kind of pull that up. I think it's really important. It's written by a man in New England, because we have this tendency to say South one way, North the other. And that's not the reality. The reality is that, this is racism, and we have it North to South, East to West. And then there's one dissent too. We'll talk about the dissent as well, who's also an interesting person to see great things and awful things from as well. Which, by the way, I got his book last week. I'm really excited.
You got the
one
the book on Separate but Equal?
No, on our one lone dissent.
Excellent. Yes, so no, it's Justice Henry Billings Brown, and I think what you see there is that this interpretation that yes, it bans outright discrimination, but racism may be tolerable because it might be social reality. That's something a lot of people agree to at this time. And that's more or less what you see in his decision, quite famously. He says, look, the object of the 14th Amendment was to enforce the absolute equality of the two races before the law, right? So we call that rule of law. But he said in the nature of things, it could not have been intended to abolish distinctions based on color, or to enforce social as opposed to political equality, or a, quote, commingling of the two races upon terms unsatisfactory to either. So again, as I said, right, this was, well, look, there's social reality. Yes, you can call it racism, but we'd say the separation, distinction of the races, that's just reality. That's just what we know, right? And therefore, the 14th Amendment has nothing to do with that, but equality before the law. And he says, also rather famously, responding to Plessy's argument, that the assumption that the enforced separation of the two races stamps African Americans with a badge of inferiority that the 13th Amendment banned, Brown said, if this be so, it is not by reason of anything found in the act, but solely because African Americans choose to put that construction on it. So he more or less blamed them for their situation. Like reading Dred Scott, this still strikes us as amazing. So who's the dissenter? Well, Kerry is talking about Justice John Marshall Harlan. And John Marshall Harlan, before the war, was a Kentucky Democrat. His family owned slaves. He was a conservative unionist Democrat during the Civil War. He fought for the Union, but he was not a Republican. He did not join the Republican Party until during Reconstruction. And it took him a long time. He actually opposed the 13th Amendment. He gave speeches against it. He opposed the 14th Amendment, but he changed his mind. Experience changed his mind and caused him to say, no, we must end this kind of discrimination, and we must find a way to enforce this equality under the law. So Harlan is an amazing story because of where he was early in the middle of his political career to really where he is right when he ends up on the bench. And he dissents in 1883. We didn't mention this case, but in the civil rights cases where the court 8-1 again strikes down the Civil Rights Act of 1875, which looked to ban discrimination in public accommodations, John Marshall Harlan dissent. And he famously used the pen of Chief Justice Taney to do so. And in Plessy, what Harlan does is says, look, we need to be honest about what this law is about. It is trying to say on its face it's not discriminatory, but we know what's happening here. We know that the court is trying to make this argument that no, there's no discrimination here, there's just social reality. Harlan says no, everyone understands the real purpose of the law. It was not neutral to exclude white people from railroad cars occupied by African Americans, but it was meant to exclude African Americans from coaches occupied whites under the guise of equal accommodation. Everyone knows it's not equal. And then famously, Harlan said, in the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. And then he finishes up by saying, in my opinion, the judgment of this day will rendered well in time proved to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. He said this will be viewed as bad as Dred Scott, and history certainly shows that John Marshall Harlan was right about this. It just took 60 years for his view to be taken up by the court.
Exactly. Now let's fast forward 60 years. It takes 60 years. And just to give everybody a frame of reference, people aren't sitting and doing nothing. They're fighting for their freedoms. They're taking every possible step to push back on the Jim Crow laws, to defend themselves, and to find ways to utilize the law and make Congress do what Congress had the power to do in the 14th Amendment, which would be enforce the law that was written. And so I always like to say, like, it's not people waiting. There's, a first civil rights movement. There's a second major civil rights movement in the 1950s and 60s, but people don't stop. But sometimes without any movement forward and many steps backwards. But we look at the Brown case and we realize, and I know we have like 1 minute left. I'd love for you to go over Brown and Loving v. Virginia really quickly for the students so they get some frame of reference and some big cases that say what is equal protection, what is due process of the law. And it's not fair, it's not equal. Equal cannot be fair. A separate cannot be equal and therefore not fair and not constitutional. So break those two down for me real quick. And you have 3 minutes, Nick, 3 minutes.
Yeah, well, and just start by saying, look, Kerry is right, that we should take these gaps in time to be suggestive that things weren't happening. The NAACP is formed in 1908, right, or 1907, 1908, and they have a legal strategy pretty quickly. And that strategy is, look, we're going to piece by piece, we're going to take about Jim Crow. We're going to attack these laws. And they do. They have successes in the 1910s, the 1920s, 1930s, 1940s. And even before Brown, they managed to successfully challenge racial discrimination in colleges and law schools. They win those cases. Brown is a big deal because it's about public education. It's about elementary schools, right? So that's the big one, right? That's the white horse, so to speak. But the NAACP has been fighting this for decades. And so it is important to always recognize that, right? That no, they did not give up. In fact, they had a strategy. They were looking far ahead and they were successful, and that's amazing, right?
And it's kind of fascinating. You talk about like long-term strategy, like these court cases were happening all over the country. And what the lawyers are doing is they're shifting and moving them up so they can get evidence in at the lower courts. So when they get to the Supreme Court, they have the best package to win. Yep. I spent like a year studying this and was like blown away at the unbelievable, brilliant strategy that you're watching happen in these court cases. And I had no idea how intricate it was and how long lasting it was. And these families are at front and center. So we look at Brown, and this is one of my favorite photos in American history, because look at the power of this young mom and this young girl and what they did, put themselves on the line to change our country.
Yeah, so obviously we unfortunately don't have as much time as we'd like to talk about Brown, but as I noted, right, part of Brown is overruling Plessy, right? And finally realizing Harlan is right? What's amazing about Brown, just to sum up quickly, right, is Brown is a 9-0 decision. When it first came to the court in 1952, and there was a conference vote, as they call it, right, when the justice first discussed the decision, the vote was 5-4 against, in favor of upholding the Kansas law and upholding Plessy. What changed is that the Chief Justice had a heart attack. He was replaced. He died. He was replaced by Earl Warren. The oral argument was reheard, and Earl Warren, step by step, convinced these justices who weren't sure about overruling Plessy because they just weren't sure if this was constitutional, what they were going to do. They had questions, but he managed to satisfy all of them. And the famous story is that Thurgood Marshall, who was representing the NAACP, was worried about dissenters. He was certain there would be dissents, if not a possible loss. And when he heard that it was going to be 9-0, a unanimous opinion, he's said to have said, "Even you, Justice Clark." It's an amazing moment. What happens here, and what Warren writes the opinion, it's very short, and he says, look, we conclude that in the field of public education, the doctrine of separate but equal, which is Plessy versus Ferguson, has no place. Separate educational facilities are inherently unequal. And the court cited all these studies. So they put in all the social science research, which not all the justices were comfortable with, but they used it to say, look, it's truly unequal, right? And therefore we can no longer allow it. So that's Brown. And then Curry asked about Loving versus Virginia. That's 13 years later. A lot happens in those 13 years, frankly. We wish we could spend 3 hours so we could tell you about all the different things that occur in this time under the Warren Court. But Loving versus Virginia has to do with what are called anti-miscegenation laws. Miscegenation is interracial marriage. And anti-miscegenation statutes had been in northern and southern states since before the Civil War. It was always considered one of those sort of final frontiers that, right, we can never allow that, right? Maybe we can have some equality, but we can't allow that. And so they had been upheld, but this was challenged under equal protection. And they were successful. Again, we have a Supreme Court decision here. As we see at the very beginning of our slides, we saw the 2015 case Obergefell dealing with gay marriage, but in order to get there, we'd had to have Loving versus Virginia, right?
And that's why I wanted you to hit that
for
for
the
students.
Promise of freedom and equality also included something that we might call a right to marriage, right? The idea that these violated both due process and equal protection, right? Because Chief Justice Warren again writes for the court and says, the freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men, right? That pursuit of happiness comes from the Declaration of Independence, of course. Marriage is a basic civil right, fundamental to our very existence and survival. So to deny this fundamental freedom on an unsupportable basis, such as racial classification, is subversive of the principle of equality at the heart of the 14th Amendment. And of course, deprives all citizens of due process as a result. So that's what the court decides, right? Is that that if there's a right to marriage, it's there because this is a fundamental part of everyone's livelihood that could not be denied on the basis of race.
And I think that's thank you, Nick, for walking us through all those pieces, but you can see how these cases kind of lay the foundation and the precedent for one to the other. Even when there's wins and loses, it's still moving the system. And we look at this big idea that the 14th Amendment wrote the promise of declaration, life, liberty, the pursuit of happiness into the Constitution, and looked to strive to push us towards a more perfect union, looking at equality and freedom. So we are way over, but that's okay because that was a really great class, Nick. Thank you so much. Students, you can all jump now. Thank you very much for hanging in there with us. And Milo, I will fix that. I think we spelled something wrong on one of the slides. I will fix that, but thank you everybody so much. If you have any questions, we will hang out for a minute, but as of right now, have a great day. See you next time in class.
All right. Then,